Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Intellectual Property Rights, PGDIPR. MIP 105 Copyright and Related Rights. Block-1 Basics of Copyright. Unit-1 Scope of Copyright. 1.1 Introduction. In this section we will look into the ideology and historical evolution of copyright. Rationale of copyright. Copyright is an intellectual property right. Like other intellectual property rights, such as patents and trademarks, it is a creation of law. It is provided to the creators of literary, dramatic, musical and artistic works. The objective of copyright protection is to ensure that creators of original works which contribute to the advancement of learning and culture gain from their intellectual productivity. There are many arguments justifying extension of rights to authors for their creativity. S.M. Stewart, in his book International Copyright in Neighboring Rights, proposes the following four major arguments in support of a statutory copyright protection regime. 5. The principle of natural justice. Since an author is the creator of a work, she has the natural right to decide who should use it. The creator is also entitled to get economic returns for his efforts. The economic argument. Creation of many works, e.g. a cinema, requires considerable investment. Even literary works require considerable investment if they are to be published and distributed. In order to attract investments, it is necessary to guarantee the investors from poaching on the works they publish by others. The cultural argument. Creative works are assets to national culture. Encouragement and rewarding of creation of works contributes to the national culture. The social argument. Dissemination of works contributes to advancement of society and in creating links between different classes and groups. Such dissemination without undermining the interests of the creators is possible through copyright protection. The Universal Declaration of Human Rights, in Article 27, advances the following justification for intellectual property right protection. 1. Everyone has the right to participate in the cultural life of the community. 2. Enjoy the arts and to share in scientific advancement and its benefits. 2. Everyone has the right to the protection of the moral and material interests resulting from any scientific, literary or artistic production of which he is the author. This sets out the need for extending statutory protection to creators for their efforts as well as the right of the community to enjoy the fruits of creativity. The Statement of Objects of the Copyright Amendment Act 1994 states, effective copyright protection promotes and rewards human creativity and is, in modern society, an indispensable support for intellectual, cultural and economic activity. It further states, copyright law promotes the creation of literary, artistic, dramatic and musical works, cinematograph films and sound recordings by providing certain exclusive rights to their authors and creators. History of copyright. It can be rightly said that copyright laws are legal responses to technological developments. While, from ancient times, society had recognized the moral rights of authors from being divested of their authorship or from changes in their works which are disparaging, and the monarchs used to reward economically those writers, musicians and artists who have earned their favor. The issue of a statutory protection system emerged after the invention of the printing press with movable typefaces in the 15th century. Gutenberg's invention of printing press in 1436 changed the publishing industry wholly. With the emergence of printing technology with movable typefaces, it has become much easier to come out with large number of copies of a book. This gave rise to a new problem. If a book has turned out to be a market success, then other publishers also printed copies of the same and fixed competitive price for the same, which made the first publisher who took the risk a loser. An act of Henry VIII in 1529 established a system of privileges for the printing of books. These privileges were trading licenses which were a kind of monopoly for the owner of the license to print and publish a book. These privileges were granted by the Crown but exercised through the Stationers' Company. In 1556, a royal charter was granted to the Stationers' Company with the objective of controlling certain types of religious literature. An order of the House of Commons in 1642 provided that the Stationers' Company should ensure that nothing was printed without the name and consent of the author. The Licensing Act of 1662 prohibited the printing of any book which was not registered with the Stationers' Company. Finally, in 1709, the Act of Queen Anne provided the authors of the books then printed the sole right of printing them for a term of 21 years and of the books not then printed, the sole right of printing for 14 years from the date of publication, which would again return to them if they are living at the end of the 14 years. This Act of Queen Anne is considered the first modern copyright law and is hailed as till mother of all copyright laws. Since then the scope of copyright was broadened much and also the period of protection got extended. The Imperial Copyright Act, 1911 consolidated the provisions of many scattered legislations into a comprehensive copyright law. It is not only Britain which provided for copyright protection. From the 18th century onwards, other countries also enacted specific legislations to extend protection for literary and artistic works. Following are the years of introduction of copyright law in some European and American countries. USA 1790. France 1793. Italy 1865. Germany 1871. Spain 1879. Russia 1925. India also has a long history in the matter of copyright legislation extending to more than a century and a half. Of course, thanks to the British rule. It was in the British India that legislation for protection of copyright, like patent, that was made. In India, the first copyright legislation is the Act of 1847, Act 20 of 1847, which was on the lines of the British Copyright Act of 1842. This was enacted during the East India Company regime. It was enacted by the Governor General in Council on the 15th of December 1847 and it affirmed the applicability of the English law to India. Not much is on record as to the enforcement of that act. Consequent on the enactment of the Comprehensive United Kingdom Copyright Act of 1911, its application was extended to the whole of British India with effect from the 31st October 1912 through a Government of India proclamation. Later, the Indian Copyright, 1914, incorporating most of the provisions of the 1911 British Act was enacted. This remained in force until the present Copyright Act of 1957 was brought into force on the 21st of January 1958. The present Copyright Act of 1957 was the result of a comprehensive review of the situation in independent India. The bill was introduced in the Parliament in October 1955. The objects and reasons for the new legislation were stated as under the existing law relating to copyright is contained in the Copyright Act 1911 of the United Kingdom, as modified by the Indian Copyright Act 1914. Apart from the fact that the United Kingdom Act does not fit in with changed constitutional status of India, it is necessary to enact an independent, self-contained law on the subject of copyright in the light of growing public consciousness and the rights and obligations of authors, and in the light of experience gained in the working of the existing law. During the last 50 years, new and advanced means of communications, like broadcasting, lithography, etc., also call for certain amendments in the existing law. Adequate provision has also to be made for fulfillment of international obligations in the field of copyright which India might expect. A complete revision of the law of copyright, therefore, seemed inevitable. The 1957 Act was amended a number of times to meet the challenges of India's international commitments in the area of copyrights and related rights as well as to adapt to the requirements of technological advancements. The Act was amended in 1983, 1984, 1992, 1994, 1999 and 2012. The 2012 amendments were quite major and covered a number of sections. The Copyright Act, 1957 was followed up by the Copyright Rules, 1958. The rules were also amended in 1984 and 1995. Presently, a new Copyright Rules, 2012, replacing the Copyright Rules, 1958, are being drafted by the government. The Copyright Act, 1957 contained detailed provisions regarding the scope of copyright, the works covered, the rights extended to the works, the penalties for infringement of the rights and exemptions and limitations to the rights. It also provided for the establishment of a copyright office for registration of copyrights, and also for the setting up of a copyright board for deciding appeals against the decisions of the registrar, and also for granting compulsory licenses as well as deciding certain issues relating to royalties, etc. The 1914 Act had no provision for registration. The 1983, 1984 and 1992 amendments were special purpose amendments. The 1983 amendment provided for certain exemptions such as compulsory licenses for translation and reproduction of foreign works for educational purposes. The 1984 amendments introduced provisions to protect the cinematograph films in sound recordings from increasing piracy through unauthorized video and audio reproductions. The 1992 amendment was for extension of the term of protection of copyright. The 1994 amendments were very comprehensive and incorporated most of the then anticipated provisions of the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS Agreement, which are applicable to copyrights. The 1999 amendment extended the scope of exemptions and limitations in regard to computer programs and also extended the period of protection of performers' rights. The 2012 amendments incorporated provisions of the WIPO Copyright Treaty, 1996 and WIPO Performances and Phonograms Treaty, 1996. These amendments expanded the scope of related rights for performers. Nature of copyright. Intellectual property rights are broadly divided into two branches, namely, copyright and neighboring rights and industrial property rights. Like other intellectual property rights, it is a property right, but the right is an intangible property. It is the right of the author in the creations of his mind expressed in a tangible format. For example, in a book of essays, the right of the author is not in the physical copy of the book in which the essays have been printed, but in his creative expressions, which are the essays. Copyright, being a property right, can be transferred or assigned to another person. It can also be inherited by the legal heirs of the author or the assignee. A copyright owner can also license specific uses, without transferring or assigning his rights. Such licenses are usually for specific purposes and specific periods. Copyrights are territorial in nature. That means that the rights are recognized and bound by the domestic legislations of the country in which the work is created. However, international treaties like the Berne Convention for the Protection of Literary and Artistic Works, the Universal Copyright Convention and the TRIPS Agreement ensure protection of copyrights of nationals of one country in the other member countries. The principle of national treatment incorporated in these treaties ensures that the nationals of a member country are extended the same treatment in regard to copyrights like the nationals of the home country. Copyright is for a limited period. After the period of protection is over, a work comes into what is referred to as public domain when every member of society can freely access and use the same. Certain other intellectual property rights, such as patents and designs, are also similarly limited in time. Copyright is not one right but a bundle of rights which extend to reproduction, distribution, communication to the public, translation, etc. of a work. These are not monopoly rights but exclusive rights. It is possible, though not very probable, for two authors to create two identical works independently. When both the works are original, both can enjoy copyright. The principle of originality in copyright means only that the work should not be copied from another work. The rights covered by copyrights are negative rights. They prevent the copying of physical material in the field of literature and arts so that the moral and material interests of the author are protected. Copyright is in the tilde-pression and not in the ideas and facts. For example, the facts of history can be expressed by different authors differently, and each one will get protectio for his expressions which form a work. Case law. The dichotomy of idea and expression is significant in copyright. How will one deal with a situation where an idea can be expressed only in one way, such as, there is only one God? If there is no other way to express _rest that idea, then can anybody claim copyright over that? The issue comes up many a time on books pertaining to mathematics. The emergence of cinematograph film as a major form of copyrighted works, also this issue acquired significance. One of the cases in India which examined the question is IGNOU versus Deluxe Films, Air. 1978 SC 1613. This case laid down very clear guidelines in the matter. Scope of copyright. The position appears to be that an idea, principle, theme, or subject matter, or historical or legendary facts being common property cannot be the subject matter of copyright of a particular person. It is always open to any person to choose an idea as a subject matter and develop it in his own manner and give expression to the idea by treating it differently from others. Where two writers write on the same subject, similarities are bound to occur because the central idea of both are the single, but the similarities or coincidences by themselves cannot lead to an irresistible inference of plagiarism or piracy. Take for instance the great poet and dramatist Shakespeare, most of whose plays are based on Greek, Roman and British mythology or legendary stories like Merchant of Venice, Hamlet, Romeo, Juliet, Julius Caesar, etc. But the treatment of the subject by Shakespeare in each of his dramas is so fresh, so different, so full of poetic exuberance, elegance and erudition, and so novel in character, as a result of which the end product becomes an original in itself. In fact, the power and passion of his expression, the uniqueness, eloquence and excellence of his style, and pathos and bathos of the dramas become peculiar to Shakespeare and leaves precious little of the original theme adopted by him. It will thus be preposterous to level a charge of plagiarism against the great playwright. In fact, throughout his original thinking, ability and incessant labor, Shakespeare has converted an old idea into a new one, so that each of the dramas constitutes a masterpiece of English literature. It has been rightly said that every drama of Shakespeare is an extended metaphor. Thus, the fundamental fact which has to be determined where a charge of violation of the copyright is made by the plaintiff against the defendant is to determine whether not the defendant not only adopted the idea of the copyrighted work but has also adopted the manner, arrangement, situation to situation, scene to scene with minor changes or superadditions or embellishment, here and why there. Indeed, if on a perusal of the copyrighted work the defendant's work appears to be a transparent rephrasing, or a copy of a substantial and material part of the original, the charge of plagiarism must stand proved. Care, however, must be taken to see whether the defendant has merely disguised piracy or has actually reproduced the original in a different form, different tone, different tenor, so as to infuse a new life into the idea of the copyrighted work adapted by him. In the latter case, there is no violation of the copyright. Thus, on a careful consideration and elucidation of the various authorities and the case law on the subject discussed above, the following propositions emerge. 1. There can be no copyright in an idea, subject matter, themes, plots, or historical or legendary facts, and violation of the copyright in such cases is confined to the form, manner and arrangement and expression of the idea by the author of the copyright work. Emphasis added. 2. Where the same idea is being developed in a different manner, it is manifest that the source being common, similarities are bound to occur. In such a case, the courts should determine whether or not the similarities are on fundamental or substantial aspects of the mode of expression adopted in the copyrighted work. 1. FTHE defendant's work is nothing but a literal imitation of the copyrighted work with some variations here and there. It would amount to violation of the copyright. In other words, in order to be actionable, the copy must be a substantial and material one, which at once leads to the conclusion that the defendant is guilty of an act of piracy. 3. One of the surest and the safest tests to determine whether or not there has been a violation of copyright is to seeing the reader, spectator, or the viewer after having read or seen both the works is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. 4. Where the theme is the same but is presented and treated differently, so that the subsequent work becomes a completely new work, no question of violation of copyright arises. 5. Where, however, apart from the similarities appearing in the two works, there are also material and broad dissimilarities which negative the intention to copy the original, and the coincidences appearing in the two works are clearly incidental, no infringement of the copyright comes into existence. 6. As a violation of copyright amounts to an act of piracy, it must be proved by clear and cogent evidence after applying the various tests laid down by the case law discussed above. 7. Where, however, the question is of the violation of the copyright of stage play by a film producer or a director, the task of the plaintiff becomes more difficult to prove piracy. It is manifest that unlike a stage play, a film has a much broader perspective, a wider field, and a bigger background, where the defendants can, by introducing a variety of incidents, give a color and complexion different from the manner in which the copyrighted work has expressed the idea, even so if the viewer after seeing the film gets a totality of impression that the film is by and large a copy of the original play, violation of the copyright may be said to be proved. 1.2 Objectives. After reading this unit, you should be able to explain the rationale for protection of copyright. Single quote. Present the historical background of protection of copyrights in India. Explain the nature of copyright. Explain the different kinds of works covered by copyright. Distinguish between what works are protected and what is not protected. And analyze the principle of originality in copyright. 1.3 WORKS. 1.3.1 Statute. Section 13 of the Copyright Act details the works in which copyright subsists. This section reads as under. 13. Works in which copyright subsists. 1. Subject to the provisions of this section and the other provisions of this Act, copyright shall subsist throughout India in the following classes of works, that is to say: A. Original literary, dramatic, musical and artistic works. B. Cinematograph films, and C. Sound recordings. 2. Copyright shall not subsist in any work specified in subsection 1, other than a work to which the provisions of Section 40 or Section 41 apply, unless I. In the case of a published work, the work is first published in India, or where the work is first published outside India, the author is at the date of such publication, or in a case where the author was dead at that date, was at the time of his death, a citizen of India. E. In the case of an unpublished work other than a work of architecture, the author is at the date of the making of the work a citizen of India, or domiciled in India, and E. In the case of work of architecture, the work is located in India. Explanation. In the case of a work of joint authorship, the conditions conferring copyright specified in this subsection shall be satisfied by all the authors of the work. 3. Copyright shall not subsist in any cinematograph film. A substantial part of the film is in infringement of the copyright in any other work. B. In any sound recording made in respect of a literary, dramatic or musical work, if in making the sound recording, copyright in such work has been infringed. 4. The copyright in a cinematograph film or a sound recording shall not affect the separate copyright in any work in respect of which, or a substantial part of which, the film, or as the case may be, the sound recording is made. 5. In the case of a work of architecture, copyright shall subsist only in the artistic character and design, and shall not extend to processes or methods of construction. 1.3.2 Works in which copyright subsists. The products protected under copyright are referred to as works, just as products protected under the Patents Act are referred to as inventions. Works are the creative expressions of persons. A work is a meaningful expression of an idea. As already mentioned, there is no copyright in ideas but in the expressions of the ideas. These expressions, however, need to convey something. They ought to be in a tangible form, although in India, oral music is also protected. They could be any of the following. A literary, dramatic, musical or artistic work. A cinematograph film, or a sound recording. The above list broadly covers almost all forms of recordings of creative expressions. The Copyright Act uses an inclusive definition of literary work in Section 2(0). It says literary work includes computer programs, tables and compilations, including computer databases. Therefore, the scope of literary work is very broad. It could be said that it includes all written or printed documents, such as stories, novels, poems, songs, screenplays, notes, speeches, essays, theses, dissertations, papers, affidavits, judgments, orders, registers, notices, written replies to communications and so on. It does not require a high literary quality or style, but should be the result of considerable labor or skill. Literary does not refer to any particular form of literature such as prose or poetry, but includes all, even ordinary private letters which may not have any literary quality and may contain grammatical errors will also qualify as literary works. Similarly, business letters and official letters also fall within the purview of literary works. A book of arithmetic is also a literary work. Even a compilation or catalog of names of products or medicines or items, if it is the result of expending of skill or labor, will also come under the category of literary work. Another example is question papers. Answer papers are also literary works. Questionnaire prepared for undertaking a research is also literary work as per the Copyright Act. In certain contexts, even meaning becomes irrelevant to qualify, such as a telegraph code or shorthand. Of course, the codes should be intelligible to the persons skilled in that area. The definition further expands the scope of literary work by specifically stating that computer programs, tables and databases are also literary works. This clarification expends the requirement of writing or printing and recognizes digital format which is only machine readable. This clarification is in line with the Agreement on Trade-Related Aspects of Intellectual Property Rights, which provides in Article 9 that computer programs, whether in source or object code, shall be protected as literary works. Dramatic works include any piece for recitation, choreographic work or even entertainment in dumb show, the scenic arrangement or acting, form of which is fixed in writing or otherwise. It, of course, does not include cinematograph films. It would, of course, include plays. Musical work is defined as meaning a work consisting of music and includes any graphical notation of such work but does not include any words or any action intended to be sung, spoken or performed with the music, thus clearly excluding from its purview the lyrics. Artistic work, again, has a wide scope. It includes a painting, a sculpture, a drawing, an engraving or a photograph, whether or not any such work possesses artistic quality. Drawing includes a diagram, map, chart or plan. It also means a work of architecture and any other work of artistic craftsmanship. The Copyright Act has put cinematograph films as a separate category of works. The definition of cinematograph film is also very broad. It includes any work of visual recording on any medium produced through a process from which a moving image may be produced by any means and includes a sound recording accompanying such visual recording, and cinematograph shall be construed as including any work produced by any process analogous to cinematography, including video films. Videotapes and digital formats fall under the definition of cinematograph films. Indian Copyright Act also extends copyrights to sound recordings. In many countries, rights over sound recordings fall under the category of related rights and not copyrights. But in India they are treated on par with cinematograph films. Sound recordings include phonograms, CDs, LPRs and any other device on which sound is recorded except those which come under the ambit of cinematograph films. Overall, the Indian Act brings within the scope of copyright a vast collection of works stretching from manuscripts to latest electronic devices to record sound, or graphics or pictures. 1.3.3 Case Law. The issue of scope of copyrighted works, however, has come under dispute in a number of cases which has resulted in getting clarity on the same. In Cambridge, Sri Krishandas vs. M.S. Garg. Therein, are not generally in themselves the proper subjects of this right, that it is difficult to say that there is any original literary work in the formation of one or two words into a title and that the words or phrase chosen may be original in their application to the subject matter of the work to which they are applied. Further, the learned author proceeds to say that titles of books are, in certain circumstances, protected from imitation by means of passing off action. The action for passing off lies where the defendant has represented to the public that his goods or business or the goods or business of the plaintiff. A defendant may make himself liable to this action by publishing a work under the same title as the plaintiff's, or by publishing a work where title and get up so resemble that of the plaintiff's to deceive the public into the belief that it is the plaintiff's work. In all these cases the plaintiff has to prove that his publication has been in the market long enough to acquire public reputation, and secondly, title used by the defendant is calculated to deceive the public. A reputation or goodwill can be built up by substantial sales within a short period of time. Mere intention to deceive is not sufficient, there must be grounds for apprehending actual deception. But it is not necessary to establish that anyone, as a result of the passing off, is induced to deal with the defendant in the mistaken view that he was dealing with. The plaintiff Copinger has on page 133 given a large number of instances where injunctions in respect of title were granted or refused, e.g., they were granted in The Wonderful Magazine, New Series Improved, Minna, Minnie Dale, London Journal, Daily London Journal, etc. They were refused in the cases of Magazine of Fiction, Monthly Magazine of Fiction, Post Office Directory of the West Riding of Yorkshire, the Post Office Bradford Directory, etc. A reference may also be made to a decision of the Chancery Division in Melder vs. Wood, 1878H Chancery Division 606. In this case, the plaintiffs were the publishers of a work, Hemi-S Royal Modern Tutor for the Pianoforte, a revised edition of which had been brought out in 1867, and which was well known and had an extensive sale, but was not so registered as to secure copyright. In 1874, the defendant employed Hemi to revise an old work, entitled Juice S. Royal Standard Pianoforte Tutor, which had formerly been in high repute, but had entirely fallen into disuse. This revised work the defendant brought out under the title, Hemi-S New and Revised Edition of Juice S. Royal Standard Pianoforte Tutor. The word, Hemi-S, both on the outside of the book and on the title page, being printed in much larger and more conspicuous type than any other of the words. The Court of Appeal held that the plaintiff was entitled to an injunction restraining the defendant from offering his work for sale with its present form, title page, and cover, or any other form, title page, or cover, calculated to deceive persons into the belief that it was the plaintiff's work. In John Hague, this brand was commonly asked for in public houses as Dimple, whiskey. In 1952, the respondent commenced selling whiskey not distilled by the petitioners in bottles of the same shape, though the labels were wholly different from those used by the petitioner. The court held that in adopting these bottles, the respondents hoped to obtain some advantage from the connection of Dimple bottles with the petitioner's whiskey. In these circumstances, the court granted an injunction restraining the respondent from selling the whiskey not blended by the petitioners in dimple bottles for consumption in the United Kingdom. Another case in which the issue of Panchang as a literary work came up was the P.R. Viswanatha Iyer v. A. Muthukumaraswamy Pillai. This case, although primarily about assignment of copyright, delved into the question of the entitlement of copyright for a Panchang. The court said, "We do not think that there is any difficulty in coming to the conclusion that the Tamil Vakya Panchangam is a literary work for the purpose of the Copyright Act, in dealing with the question of the degree of originality necessary to constitute original literary work for the purpose of the Copyright Act, 1911, the Privy Council in the case of Macmillan expended. To secure copyright for this product, it is necessary that the labor, skill and capital expended should be sufficient to impart to the product some quality or character which the raw material did not possess, and which differentiates the product from the raw material." Then again at page 327, quoting the observations of Peterson, J., in University of London Press, Limited v. University Tutorial Press, Limited 1916-2 ch. 601. Their Lordships approved the following passage in connection with the meaning of the words, original literary work, in section 1, subsection 1, of the Act of 1911. The word, original, does not in this connection mean that the work must be the expression of the original or inventive thought. Copyright acts are not concerned with the originality of ideas, but with the expression of thought, and, in the case of literary work, with the expression of thought in print or writing. The originality which is required relates to the expression of the thought. But the Act does not require that the expression must be in an original or novel form, but that the work must not be copied from another work, that it should originate from the author. Their Lordships go on to state, what is the precise amount of the knowledge, labor, judgment or literary skill or taste which the author of any book or other compilation must bestow upon its composition in order to acquire copyright in it, within the meaning of the Copyright Act, 1911, cannot be defined in precise terms. In every case it must depend largely on the special facts of that case, and must in each case be very much a question of degree. The appellant on this part of the case has relied strongly on the decision of G.A. Cramp, not been established for the diary in question, which was a mere calendar with the addition of a certain amount of miscellaneous information, all accessible in official publications and a feature of all diaries of the kind. The learned Lord Chancellor observes, quote, "There would, indeed, as it seems to me, be considerable difficulty in successfully contending that ordinary tables which can be got from, or checked by, the postal guide or the nautical almanac are a subject of copyright as being original literary work. One of the essential qualities of such tables is that they should be accurate, so that there is no question of variation in what is stated. The sun does in fact rise, and the moon set, at times which have been calculated, and the utmost that a table can do on such a subject is to state the result accurately. There is so far no room for taste or judgment. There remains, I agree, the element of choice as to what information should be given, and the respondents contend that the test of originality is satisfied by the choice of the tables inserted, but the bundle of information furnished in the respondent's diary is commonplace information, which is ordinarily useful and is, at any rate, to a large extent, commonly found prefixed to diaries, and, looking through the respondent's collection of tables, I have difficulty in seeing how such tables, in the combination in which they appear in the respondent's 1933 diary, can reasonably claim to be original work. There was no evidence that any of these tables was composed specially for the respondent's diary. There was no feature of them which could be pointed out as novel or specially meritorious or ingenious from the point of view of the judgment or skill of the compiler. It was not suggested that there was any element of originality or skill in the order in which the tables were arranged. My own conclusion is that the selection did not constitute an original literary work. R. Having brought in the arguments that would go against calendars, diaries and Panchangs, the Humboldt court stated. Now, if the Tinavali Vakya Panchangam was nothing more than handy extract from published official tables, the reasoning of the Lord Chancellor in the case just cited might well be applicable, but the evidence in this case does show that this Panchangam is an original composition worked out by a series of calculations based on a fairly elaborate set of rules in the knowledge of which the first defendant is an admitted specialist. He does not compile his Panchangam by copying information from other publications. He has a specialized knowledge of a fairly elaborate system for working out these matters year by year, and it is the result of his own calculations made with reference to the particular locality that enables him to fix not only the dates but the precise hour and minute for the commencement and termination of each particular period, the fixation of which is essential in order to know the proper time for performing a particular ceremony, or celebrating a particular festival, or for casting the horoscope of a person born on a particular date and hour. We have, therefore, no difficulty in holding that the work in question is an original literary work for the purpose of the Copyright Act, 1911. The court has thus brought in the concept of original expressions of new thoughts or facts which are the result of labor or skill as qualifying criterion for copyright protection. 1.4 Originality in copyright. The most fundamental concept in copyright is that of originality. Copyright extends to original works only. Therefore, the first challenge to any work is on its originality, since that is the one which makes it eligible for copyright protection. If a work is not original, then it is a copy and attracts the charge of infringement. The Copyright Act neither defines originality nor explains the concept. Therefore, commentators have to rely on various court laws to understand what is covered by originality in copyright. The courts, in India and UK as well as in other countries, of course, have dealt with the issue in detail. In one of the early cases, University of London Press Limited versus University Tutorial Press Limited, 1916, the court observed that the word original does not mean that the work must be the expression of original or inventive thought. Copyright acts are not concerned with the originality of ideas, but with the expression of thought. The originality which is required relates to the expression of the thought, but the act does not require that the expression must be in an original or novel form, but that the work must not be copied from another work, that it should originate from the author. Courts in UK, India and other countries consistently followed this principle in regard to originality. When cases of infringement come before the courts, they generally look into whether the impugned work is a result of expending of sufficient skill and labor by the author. Facts, ideas and words come from common sources. For example, a dictionary contains only words which have already been in use, and most dictionaries share most of the words. But in this case the originality is in the way the author or compiler explains the meaning and the effort he has taken to collect the words. Same is the case with most compilations such as telephone directories or catalogs. Courts generally take the view that so long as a work is not the result of substantial copying from another source, then it is original. What they say is that it must originate from the author and not from another person. In a famous case in the United States of America, Frederick Lymanson v. Chas. Davies, quoted in Story's United States Representative, the same principle is elucidated in the following words.
First, that any new or original plan, arrangement or compilation of material will entitle the author to copyright therein, whether the material themselves be old or new. Second, that whosoever by his own skill, labor and judgment writes a new work may have a copyright therein, unless it be directly copied or evasively imitated from another's work. Third, that to constitute piracy of a copyright it must be shown that the original has been either substantially copied or to be so imitated as to be a mere evasion of the copyright. In Veil on Copyright also the point of originality is discussed in the following words. Originality is not to be equated with the creation of something which had not hitherto existed. It is the word used to describe the casual relationship between an author and the material from which a work is embodied. Thus, if a politician makes an impromptu speech and a reporter copies it verbatim, the reporter is the author of an original literary work because the letters which compose it were first rendered down by him. But if the politician had read a scripted speech, he, and not the reporter, would be the author. In any event, originality of subject matter is not a requirement of copyright. Such unoriginal, in the colloquial sense, works as football pools coupons, lists of football fixtures, instructions for the use of weed killers and examination questions are quite capable of being, in law, original works. Case law. In the case P.R. Vishwanatha Iyer vs. A. Muthukumaraswamy Pillai, Air 1948. Matt J. 39, the issue of originality necessary to constitute original literary work for the purpose of the Copyright Act, 1911 was examined in the context of a Panchang, Tinivli Vakya Panchangam. The court reiterated to secure copyright for this product it is necessary that the labor, skill and capital expended should be sufficient to impart to the product some quality or character which the raw material did not possess, and which differentiates the product from the raw material. It further stated that the word original does not mean that the work must be the expression of original or inventive thought. Copyright acts are not concerned with the originality of ideas, but with the expression of thought, and, in the case of literary work, with the expression of thought in print or writing. The originality which is required relates to the expression of the thought, but the act does not require that the expression must be in an original or novel form, but that the work must not be copied from another work, that it should originate from the author. The court admitted that the precise amount of the knowledge, labor, judgment, or literary skill or taste which the author of any book or other compilation must bestow upon its composition in order to acquire copyright in it thus depends on the special facts of each case, and very much a question of degree. In V. Erabhadrarao vs. B. J. Y. Sarma, Air 1960 AP 415, the issue of originality in the context of a translation done under the guidance and directions of an editorial board came up. This was the case of a Telugu rendering of the book, India's Police Action Against Hyderabad. The person who wrote the preface observed that although the author has drawn some materials from the original English work of the appellants, he has added many things from history and other sources. It would be proper to say that facts have been taken from it as they are, and an attempt is made to develop them to make the book more informative and interesting. Many matters which are of interest to public have been added. The efforts made by our friend Mr. B. N. Sama to render it into a lucid style, devoid of tedium, are praiseworthy. The court said, "We have no hesitation in finding that this book is an original composition of Mr. Sama written in Telugu, no doubt from the materials gathered partly from the appellant's books, and partly from his own writings and historical facts. By an original composition we do not mean to convey that it is confined to a field which has never been traversed hitherto by any other person or persons, either in respect of ideas or material comprised therein. Indeed, such contributions are few, as most works must depend upon the contribution of others, using them as steps in aid of reaching a particular object which may be original in its design and conception." The court also set the norms for originality in the following words: "The originality which is required relates to the expression of thought, and that the work should not be copies from another work, but should be original from the author. Much depends on the skill, labor, knowledge and the capacity to digest and utilize the raw materials contributed by others in imparting to the product the quality and character which those materials did not possess, and which differentiates the product from the materials used." The judge also relied on the arguments used in a celebrated judgment in Frederick Emerson vs. Chas Davies, Stories United States Representative Vol. 3 page 768, which set out the distinction between the original composition and a piracy of a copyright. Some of the points decided are stated in the head note to be, first, that any new and original plan, arrangement or compilation of material will entitle the author to copyright therein whether the materials themselves be old or new. Second, that whosoever by his own skill, labor and judgment writes a new work may have a copyright therein unless it be directly copied or evasively imitated from another's work. Third, that to constitute piracy of a copyright it must be shown that the original has been either substantially copied or to be so imitated as to be a mere evasion of the copyright. The question of originality in database is a sticky issue. Most databases these Days are made through electronic means. How the originality in such a situation will be addressed? The case of Burlington Home Shopping Private vs. Rajneesh Chibbar, 1995 IVAD Delhi 732, throws light on this. The questions which arise for consideration are whether a database consisting of compilation of mailing addresses of customers can be subject matter of a copyright and whether the defendant can be said to have committed infringement of the plaintiff's copyright. A few provisions of the Copyright Act 195-7, as amended by the Copyright Amendment Act, 1994, Act No. 38 of 1994, may be looked into. Section 2.0 defines literary work to include, among others, computer programs, tables, and compilations including computer databases. Section 2.y defines work as meaning any of the following works, namely, I, a literary, dramatic, musical or artistic work, e, a cinematographic film, e, sound recording. Under Section 14, literary work is one of the items wherein exclusive rights can be claimed so as to amount to copyright. Under Section 17, c, if a work is made in the course of others' employment under a contract of service or apprenticeship, it is the employer who is the first owner of the copyright therein in the absence of any agreement to the contrary. Laddie, Prescott and Victoria have stated in the Modern Law of Copyright 1980 edition, form in which program or data is expressed 2.138 LF. A program or collection of data is first expressed in the form of invisible magnetic patterns. J1 a tape, and still more if in the form of coarse storage, it is doubtful whether this constitutes writing within the meaning of the Act. Writing is defined as including any form of notation, whether by hand or by printing, typewriting or any similar process, although it is arguable that notation should be given a wide meaning. There may be some difficulty in accepting that it includes the magnetization states of an array of rings on wires, and all the concrete instances given in the definition involve visible symbols appreciable directly by humans. However, if the view be correct that a literary work need not be expressed in writing, these difficulties largely disappear, and all the more so if it be accepted that the literary work is the thing which is the product of the author's mind. Copinger. They further state, TRADE catalogs are generally compilations, and as such are capable of protection as literary works. On similar principles, a computer database, stored on tape, disk or by other electronic means, would also generally be a compilation and capable of protection as a literary work. David Bainbridge has in Software Copyright Law, at p.48, dealt with computer database in the following terms. A computer database is a collection of information stored on computer media. The information may be a list of clients and their addresses, or it may be the full text of various documents, or it may be a set of coordinates relating to a three-dimensional building structure. The range of things which may be included in a computer database is enormous. The information contained in the database may itself be confidential and protected by the law of breach of confidence, but what of the copyright position? The simplest way of looking at a computer database is to consider the work it represents. For example, a printed listing of names and addresses, a printed set of documents, or a drawing of a building. Those works are protected by copyright as literary or artistic works. It does not matter if the work is never produced on paper and only ever exists on computer storage media. Example, XYZ Supplies Limited has a computer database containing names, addresses, telephone and fax numbers of customers. This database has been developed over a couple of years, and it is usual for a new customer's details to be entered directly into the computer by XYZ's telesales staff without a written record being made. The customer database is protected by copyright as an original literary work, assuming a modicum of skill and judgment is involved in compiling the database. For example, if the telesales staff have to exercise judgment in deciding whether to accept a new customer, being a compilation, it is a literary work. By storing the information in a database, it has been recorded in writing or otherwise, as required by the Act. Writing is defined widely and includes any form of notation or code regardless of the method or medium of storage. Even if the database is never printed out on paper, it will be protected by copyright. Looking into the issue of trade secret law and copyright law protection for database, the court quoted from the book Copyright, Principles, Law and Practice, Volume 2, Para 15.11.1.2, of Paul Goldstein. customer lists and other compilations of business data may be copyrightable as fact works. In theory, copyright and trade equals law protect different elements of compiled business data, with copyright protecting the expression in these compilations and trade secret law protecting the underlying data. In fact, copyright and trade secret protection for compilations of business data frequently converge. Copyright protection for business directories often extends to the underlying data, and trade secret protection may extend to particular expressive arrangements of data. The court further stated that the same author in Copyright Voi.1 at para 2, 16. 1.1 states, database designers typically arrange the stored data in ways that, though unintelligible to the user, will increase the efficiency of the database by making the stored data most easily accessible. Most, if not all, of these arrangements probably contain sufficient authorship to satisfy the originality requirements. If the compiler selected the data for the database from a larger mass of data, protection may extend to her particular selection as well. The court again observed, in footnote 21, below para 2.12.1.1, the same author states, protection for the arrangement within the database will give the copyright owner rights only against someone, typically a competitor, when directly copies expression embodying that arrangement from the database. The court also examined a few decided cases. In Waterloo Directors Limited vs. Reed Information Service Limited, 1992 FSR, Fleet Street Report, 409, the names and addresses appearing in the plaintiff's directory, but not in the defendant's directory, were copied onto a word processor which was used to produce letters inviting the prospective clients to appear in the new editions of the defendant's directory. It was held, it was clear that a person could not copy entries from a directory and use such copies to compile his own directory, even if it was correct that a person could use the information in a directory to compile another directory provided that reproduction did not take place. That was not the case before the court. The defendant had reproduced the names and addresses from the plaintiff's directory onto a word processor and a computer. Quote. William Hill, Football, Limited vs. Ladbroke, Football, Limited, 1980 RPC 539, was a case of compilation of certain lists by the plaintiff which were copied down by the defendant. It was held, in my judgment, the selection of those 16 lists and the writing of them down in the coupon, with headings and notes, is a compilation which is the subject of copyright. Quote. Another case examined was that of Govindam vs. Gopalakrishna. Here also the issue was copyright in compilation. In this case it was held that though in the case of compilation, the amount of originality will be very small, but even that small amount is protected by law and no man is entitled to steal or appropriate for himself the result of another's brain, skill or labor even in such works. On the defense plea of common source, it was held, a person relying on it must show that he went to the common source from which he borrowed, employing his skill, labor and brains, and that he did not merely do the work of the copyist by copying away from another work. Quote. Point 1. In the case of Shyam Lal Paharia vs. Gaya Prasad, Air 1971 Allahabad 182, also it was held that a compilation derived from a common source falls within ambit of literary work, a work of compilation of a nature similar to that of another will not by itself constitute an infringement of the copyright of another person's work written on the same pattern. The question whether an impugned work is colorable imitation of another person's work is always a question of fact. The determining factor is to see whether the impugned work is a slavish imitation and a copy of another person's work, or it bears the impress of the author's own labors and exertions. The learned judge has during the course of his judgment laid down a few principles based on a review of the case law which are reproduced hereunder so far as relevant for the decision of the case at hand. 1. A compilation which may be derived from a common source falls within the ambit of literary work. 2. A work of compilation of a nature similar to that of another will not by itself constitute an infringement of the copyright of another person's work written on the same pattern. 3. The question whether an impugned work is a colorable imitation of another person's work is always a question of fact and has to be determined from the circumstances in each case. 4. The determining factor in finding whether another person's copyright has been infringed is to see whether the impugned work is a slavish imitation and copy of another person's work, or it bears the impress of the author's own labors and exertions. The aforesaid principles are by no means exhaustive. From the above statement of the authorities and the trend of judicial opinion, it is Clear that a compilation of addresses developed by anyone by devoting time, money, labor and skill, though the sources may be commonly situated, amounts to a literary work wherein the author has a copyright. Another case in which the issue of originality was discussed in detail was the Eastern Book Company vs. D.B. Modak, 2008-1 SC 1, although in the context of reporting of orders of the courts, the judgment examined the various aspects that are pertinent to be considered for a work to be treated as original literary work. After examining the statutory provisions regarding copyright in judgments of the courts, the bench observed the judicial pronouncements of the apex court would be in the public domain, and its reproduction or publication would not infringe the copyright. The reproduction or publication of the judgments delivered by the Supreme Court by any number of persons would not be infringement of a copyright of the first owner thereof, namely, the government, unless it is prohibited. The question, therefore, is whether by introducing certain inputs in a judgment delivered by a court it becomes original copy edited judgment, and the person or authority or company who did so could claim to have embodied the originality in the said judgment, and the judgment takes the color of original judgment having a copyright therein of its publisher. In many cases, a work is derived from an existing work. Whether in such a derivative work, a new copyright work is created, will depend on various factors, and would one of them be only skill, capital and labor expended upon it to qualify for copyright protection in a derivative literary work created from the pre-existing material in the public domain, and the required exercise of independent skill, labor and capital in its creation by the author would qualify him for the copyright protection in the derivative work? Or would it be the creativity in a derivative work in which the final position will depend upon the amount and value of the corrections and improvements, the independent skill and labor, and the creativity in the end product is such as to create a new copyright work to make the creator of the derivative work the author of it, and if not, there will be no new copyright work, and then the original author will remain the author of the original work, and the creator of the derivative work will have been the author of the alterations or the inputs put therein, for their nature will not have been such as to attract the protection under the law of copyright. The word original does not mean that the work must be the expression of original or inventive thought. Copyright acts are not concerned with the originality of ideas, but with the expression of thought, and in the case of literary work, with the expression of thought in print or writing. The originality which is required relates to the expression of the thought, but the act does not require that the expression must be in an original or novel form, but that the work must not be copied from another work, that it should originate from the author. And as regards compilation, originality is a matter of degree depending on the amount of skill, judgment or labor that has been involved in making the compilation. The words literary work, cover work which is expressed in print or writing, irrespective of the question whether the quality or style is high. The commonplace matter put together or arranged without the exercise of more than negligible work, labor and skill in making the selection will not be entitled to copyright. The word original does not demand original or inventive thought, but only that the work should not be copied but should originate from the author. In deciding, therefore, whether a work in the nature of a compilation is original, it is wrong to consider individual parts of it apart from the whole. For many compilations have nothing original in their parts, yet the sum total of the compilation may be original. In such cases, the courts have looked to see whether the compilation of the unoriginal material called for work or skill or expense. If it did, it is entitled to be considered original and to be protected against those who wish to steal the fruits of the work or skill or expense by copying it without taking the trouble to compile it themselves. In each case, it is a question of degree whether the labor or skill or ingenuity or expense involved in the compilation is sufficient to warrant a claim to originality in a compilation. After examining a number of previous judgments on the issue of originality, the court stated, quote, "These decisions are the authority on the proposition that the work that has been originated from an author and is more than a mere copy of the original work would be sufficient to generate copyright. This approach is consistent with the sweat of the brow standards of originality. The creation of the work which has resulted from little bit of skill, labor and capital are sufficient for a copyright in derivative work of an author." Decisions propounded a theory that an author deserves to have his or her efforts in producing a work rewarded. The work of an author need not be in an original form or novel form, but it should not be Copied from AI, zero to his work, that is, it should originate from the author. The originality requirement in derivative work is that it should originate from the author by application of substantial degree of skill, industry or experience. Precondition to copyright is that work must be produced independently and not copied from another person. Where a compilation is produced from the original work, the compilation is more than simply a rearranged copyright of original, which is often referred to as skill, judgment and/or labor or capital. The copyright has nothing to do with originality or literary merit. Copyrighted material is that what is created by the author by his skill, labor and investment of capital, maybe. It is derivative work. The courts have only to evaluate whether derivative work is not the end product of skill, labor and capital which is trivial or negligible, but substantial. The courts need not go into evaluation of literary merit of derivative work or creativity aspect of the same. It is submitted by the learned counsel for the respondents that for a derivative work, the originality test as applied in United States Supreme Court should be made applicable, whereby the author of a derivative work would satisfy that the work has been produced from his exercise of skill and judgment. The exercise of skill and judgment required to produce the work must not be so trivial that it could be characterized a purely mechanical exercise. The work should be independently created by the author as opposed to copied from the other works, and that it possesses at least some minimal degree of creativity. The case law relied upon by the learned counsel for the respondents is considered hereinafter. In Feist Publications Inc. vs. Rural Telephone Service Company, Inc., 18 USP Q2D, 1275, Rural Telephone Service Company publishes a typical telephone directory consisting of white pages and yellow pages. The white pages list in alphabetical order the names of rural subscribers together with their towns and telephone numbers. The yellow pages list rural's business subscribers alphabetically by category and feature classified advertisements of various sizes. To obtain white pages listings for its area-wide directory, Feist Publications Inc. approached different telephone companies operating in northwest Kansas and offered to pay for the right to use their white pages listings. Of them, only rural refused. Unable to license rural's white pages listings, Feist used them without rural's consent. Rural sued for copyright infringement in the district court, taking the position that Feist, in compiling its own directory, could not use the information contained in rural's white pages. Rural asserted that Feist's employees were obliged to travel door to door or conduct a telephone survey to discover the same information for themselves. Feist responded that such efforts were economically impractical and, in any event, unnecessary because the information copied was beyond the scope of copyright protection. The United States Supreme Court held that the sine qua non of copyright is originality. To qualify for copyright protection, a work must be original to the author. Original, as the term is used in copyright, means only that the work was independently created by the author, as opposed to copied from other works, and that it possesses at least some minimal degree of creativity. The requisite level of creativity is extremely low, even a slight amount will suffice. The vast majority of works make the grade quite easily, as they possess some creative spark, no matter how crude, humble or obvious it might be. Originality does not signify novelty. A work may be original, even though it closely resembles other works, so long as the similarity is fortuitous, not the result of copying. The court further held that no one claim originality as to the facts. This is because facts do not owe their origin to an act of authorship. The distinction is one between creation and discovery. The first person to find and report a particular fact has not created the fact, he or she has merely discovered its existence. Factual compilations, on the other hand, may possess the requisite originality. The compilation author typically chooses which facts to include, in what order to place them, and how to arrange the collected data so that they may be used effectively by readers. These choices as to selection and arrangement, so long as they are made independently by the compiler and entail a minimal degree of creativity, are sufficiently original. Thus, if the compilation author clothes facts with an original collocation of words, he or she may be able to claim a copyright in this written expression. The court goes on to hold that the primary objective of copyright is not to reward the labor of authors, but to promote the progress of science and useful arts. To this end, copyright assures authors the right to their original expression but encourages others to build freely upon the ideas and information conveyed by a work. Only the compiler's selection and Arrangement may be protected, however, the raw facts may be copied at will. The court rejected the doctrine of the sweat of the brow as this doctrine had numerous flaws, the most glaring being that it extended copyright protection in a compilation beyond selection and arrangement, the compiler's original contributions to the facts themselves. A subsequent compiler was not entitled to take one word of information previously published, but rather had to independently work out the matter for himself, so as to arrive at the same result from the same common sources of information. Sweat of the brow courts thereby eschewed the most fundamental axiom of copyright law that no one may copyright facts or ideas. The sweat of the brow doctrine flouted basic copyright principles, and it creates a monopoly in public domain materials without the necessary justification of protecting and encouraging the creation of writings by authors. R. The judgment in Matthew Bender. It alters these texts into independently composed features, such as syllabus, head notes which summarize the specific points of law recited in each opinion, and key numbers which categorize points of law into different legal topics and subtopics, and additions of certain factual information to the text of the opinions, including parallel or alternative citations to cases, attorney information, and data on subsequent procedural history. West publishes the case reports in different series of case reporters collectively known as National Reporter System. 2. Series of case reporters at issue in that case were the Supreme Court Reporter and the Federal Reporter. Hyperlaw publishes and markets CD-RAMs, which are compilations of the Supreme Court and the United States Court of Appeals that cover approximately the same ground. Hyperlaw intends to expand its CPROM product, taking the material from the West publications. Hyperlaw intervened and sought a judgment declaring that the individual West case reports that are left after redaction of the first category of alterations do not contain copyrightable material. It was held by the court that for copyright protection, the material does not require novelty or invention, but minimal creativity is required. All of West's alterations to judicial opinions involve the addition and arrangement of facts, or the rearrangement of data already included in the opinions, and, therefore, any creativity in these elements of West's case reports lies in West's selection and arrangement of this information. West's choices on selection and arrangement can reasonably be viewed as obvious, typical, and lacking even minimal creativity. Copyright protection is unavailable for both derivative works and compilations alike unless, when analyzed as a whole, they display sufficient originality so as to amount to an original work of authorship. Originality requires only that the author makes the selection or arrangement independently and that it displays some material with minimal level of creativity. While a copy of something in the public domain will not, if it be merely a copy, support a copyright. A distinguishable variation will. To support a copyright there must be at least some substantial variation, not merely a trivial variation such as might occur in the translation to a different medium. Creativity in selection and arrangement, therefore, is a function of the total number of options available, external factors that limit the viability of certain options and render others non-creative, and prior uses that render certain selections garden variety. In the case of K-Tilde Publications, Inc. v. Chinatown Today Publishing Enterprises, Inc., 945 F2D.509, key publication published an annual classified business directory for New York City's Chinese American community. In 1990, Galore publication published the Galore Directory, a classified directory for the New York Chinese American community. Key brought a suit against Galore Directory, charging that Galore Directory infringed Key's copyright in the 1989-90 Key Directory. The United States Court of Appeal held that individual components of compilation are generally within the public domain and thus available for public. There are three requirements for a compilation to qualify for copyright protection. 1. The collection and assembly of pre-existing data. 2. Selection, ordination or arrangement of the data. And 3. The resulting work that comes into being is original, by virtue of the selection, coordination or arrangement of the data contained in the work. For originality, the work is not required to contain novelty. The doctrine of sweat of the brow rewarded compilers for their efforts in collecting facts with a de facto copyright to those facts, and this doctrine would preclude the author absolutely from saving time and effort by referring to and relying upon prior published material. It extended copyright protection in compilation beyond selection and arrangement. The compiler's original Contribution to the facts themselves drawn on sweat of the brow is a copyright protection to the facts discovered by the compiler. The court discarded sweat of the brow notion of copyright law. R. In Macmillan and Company vs. K. and J. Cooper, 1924 Privy Council 75, action was brought by Macmillan and Company to restrain the respondent firm who was carrying on the trade and business of publishers of educational books from printing, distributing or otherwise disposing of copies of the book published by the appellants. The ground on which the relief was claimed was that the appellants had a copyright in the book entitled Plutarch's Life of Alexander, Sir Thomas North's translation, and that the respondent published subsequently a book entitled Plutarch's Life of Alexander the Great, North's translation, as it had infringed the copyright to which the appellants were entitled in the earlier compilation. The court noted the contents of the book of the appellants as also that of the respondent. As per the court, the text of the appellant's book consisted of a number of detached passages, selected from Sir Thomas North's translation, words being in some instances introduced to knit the passages together so that the text should, as far as possible, present the form of an unbroken narrative. The passages so selected were, in the original translation, by no means contiguous. Considerable printed matter in many instances separated the one from the other. The opinion of the Privy Council was that for the work done by the appellants, great knowledge, sound judgment, literary skill or taste in the inputs brought to bear upon the translation was not required, as the passages of the translation, which had been selected, are reprinted in their original form, not condensed, expanded, modified or reshaped to any extent whatever. The court observed that the North's translation of Plutarch's Life of Alexander does not and never did, as the law stands, never can enjoy the protection of copyright, and they questions which arise for decision must be dealt with upon that assumption. The court said that in all cases where the reprint with the text of it consisted merely of a reprint of passages selected from the work of any author, would never have a copyright. There may be cases where selecting and reprinting the passages would require the appreciation upon what has been laid down or established in the book and labor, accurate scientific knowledge, sound judgment, touching the purpose for which the selection is made, and literary skill would all be needed to affect the object in view. In such a case, the copyright might well be acquired for the print of the selected passages. The court said that it is the product of the labor, skill and capital of one man which must not be appropriated by another, not the elements, the raw material, upon which the labor and skill and capital of the first have been expended. To secure copyright for this product, it is necessary that the labor, skill and capital expended should be sufficient to impart to the product some quality or character which the raw material did not possess and which differentiates the product from the raw material. The court approved the principles enunciated in the case of University of London Press, Limited vs. University Tutorial Press, Limited, 1916, 2 ch. 601, dealing with the meaning of the words original, literary work, that the original does not mean expression of original or inventive thought. The Copyright Act is not concerned with the original ideas, but with the expression of thought. The originality which is required relates to expression of thought, and the Act does not require that the expression must be in original or novel form. The work must not be copied from another work, that it should originate from the author. The Supreme Court of Canada in the matter of CCH Canadian Limited vs. Law Society of Upper Canada, 2004, 1339 Seychelles rupees, Canada, has noticed the competing views on the meaning of original in copyright law, wherein some courts have held that a work which has originated from an author and is more than a mere copy of a work is sufficient to give copyright. This approach is held to be consistent with the sweat of the brow or industriousness standard of originality, on the premise that an author deserves to have his or her efforts in producing a work rewarded, whereas the other courts have held that a work must be creative to be original and thus protected by the Copyright Act, which approach is consistent with the natural rights theory of property law. However, it is less absolute in that only those works that are the product of creativity will be rewarded with copyright protection, and it was suggested in those decisions that the creativity approach to originality helps ensure that copyright protection is extended to the expression of ideas as opposed to the underlying ideas or facts. The court has also noticed that those cases which had adopted the sweat of the brow approach to originality should not be interpreted as concluding that labor, in and of itself, would be a ground for finding of originality. The question for consideration of the copyright has arisen on the following fact foundation. The appellant, Law Society of Upper Canada, has maintained and operated the Great Library at Osgood Hall in Toronto. A reference and research library. The Great Library provides a request-based photocopy service for Law Society members, the judiciary and other authorized researchers. Under the custom photocopy service, legal materials are reproduced and delivered to the requesters. The Law Society also maintains self-service photocopiers in the Great Library for use by its patrons. The respondents, CCH, Canadian Limited, Thomson Canada Limited, and Canada Law Book Inc. publish law reports and other legal materials. The law book publishers commenced copyright infringement action against the Law Society, claiming ownership of copyright in 11 specific works on the ground that the Law Society had infringed copyright. When the Great Library reproduced a copy of each of the works, the publishers further sought permanent injunction prohibiting the Law Society from reproducing these 11 works as well as any other works that they published. The Law Society denied liability and submitted that the copyright is not infringed when a single copy of a reported decision, case summary, statute, regulation or a limited selection of text from a treatise is made by the Great Library staff or one of its patrons on a self-service photocopier for the purpose of research. The court was called upon to decide the question as to what shall be the originality in the work of compilation. On consideration of various cases, it was held that to be original under the Copyright Act, the work must originate from an author, not be copied from another work, and must be the product of an author's exercise of skill and judgment. The exercise of skill and judgment required to produce the work must not be so trivial that it could be characterized as a purely mechanical exercise. Creative works by definition are original and are protected by copyright, but creativity is not required in order to render a work original. The original work should be the product of an exercise of skill and judgment, and it is a workable yet fair standard. The sweat of the brow approach to originality is too low a standard which shifts the balance of copyright protection too far in favor of the owner's right, and fails to allow copyright to protect the public's interest in maximizing the production and dissemination of intellectual works. On the other hand, the creativity standard of originality is too high. A creative standard implies that something must be novel or non-obvious, concepts more properly associated with patent law than copyright law. By way of contrast, a standard requiring the exercise of skill and judgment in the production of a work avoids these difficulties and provides a workable and appropriate standard for copyright protection that is consistent with the policy of the objectives of the Copyright Act. Thus, the Canadian Supreme Court is of the view that to claim copyright in a compilation, the author must produce a material with exercise of his skill and judgment which may not be creativity in the sense that it is not novel or non-obvious, but at the same time it is not the product of merely labor and capital. It is the admitted position that the reports in the Supreme Court cases, SCC, of the judgments of the Supreme Court is a derivative work in public domain. By virtue of Section 52(1) of the Act, it is expressly provided that certain acts enumerated therein shall not constitute an infringement of copyright. Subclause IV of Clause Q of Section 52(1) excludes the reproduction or publication of any judgment or order of a court, tribunal or other judicial authority, unless the reproduction or publication of such judgment or order is prohibited by the court, the tribunal or other judicial authority from copyright. The judicial pronouncements of the apex court would be in the public domain and its reproduction or publication would not infringe the copyright. That being the position, the copy-edited judgments would not satisfy the copyright merely by establishing amount of skill, labor and capital put in the inputs of the copy-edited judgments, and the original or innovative thoughts for the creativity are completely excluded. Accordingly, original or innovative thoughts are necessary to establish copyright in the author's work. The principle where there is common source, the person relying on it must prove that he actually went to the common source from where he borrowed the material, employing his own skill, labor and brain, and he did not copy, would not apply to the judgments of the courts, because there is no copyright in the judgments of the court, unless so made by the court itself. To secure a copyright for the judgments delivered by the court, it is necessary that the labor, skill and capital invested should be sufficient to communicate or impart to the judgment printed in SCC some quality or character which the original judgment does not possess and which differentiates the original judgment from the printed one. The Copyright Act is not concerned with the Original idea but with the expression of thought. Copyright has nothing to do with originality or literary merit. Copyrighted material is that what is created by the author by his own skill, labor and investment of capital. Maybe it is a derivative work which gives a flavor of creativity. The copyright work which comes into being should be original in the sense that by virtue of selection, coordination or arrangement of pre-existing data contained in the work, a work somewhat different in character is produced by the author. On the face of the provisions of the Indian Copyright Act, 1957, we think that the principle laid down by the Canadian court would be applicable in copyright of the judgments of the apex court. We make it clear that the decision of ours would be confined to the judgments of the courts which are in the public domain, as by virtue of Section 52 of the Act there is no copyright in the original text of the judgments. To claim copyright in a compilation, the author must produce the material with exercise of his skill and judgment, which may not be creativity in the sense that it is novel or non-obvious, but at the same time it is not a product of merely labor and capital. The derivative work produced by the author must have some distinguishable features and flavor to raw text of the judgments delivered by the court. The trivial variation or inputs put in the judgment would not satisfy the test of copyright of an author. On this touchstone, we shall take into consideration the inputs put by the appellants. In their journal SCC, the appellants have added in the copy-edited version the raw citations to the citations already given in the original text, added names of cases and cross-citations where only the citation of the case is given, added citation and cross-citations where only name of the case is given, inserted citation in case history where only the title and year of the impugned earlier order is given, presented in their own style the cases when they are cited repeated in the judgment, provided precise references to the quoted matter in the judgment by giving exact page and paragraph number as in the original case source, treatise, reference material, added margin headings to quoted extracts from statutes, rules, etc. When they are missing from the original text of the judgment, added the number of the section, rule, article, paragraph to the extract quoted in the original text, added the names of judges on whose behalf opinion given by giving expressions such as for himself and Pathak, CJ etc., done verification of first word of the quoted extract and supplied emphasis on such verification, added ellipsis to indicate breaks in quoted extract, provided and supplied the matter inadvertently missed in quoted extracts in the original text of the judgment, completed, corrected the incomplete, incorrect case names or citations, renumbered correctly the clauses, sub-clauses in terms of the questions framed which were numbered in terms of answers to questions framed by learned judge, changed the text as per core agenda issued, which has been issued upon SCC editor's request and suggestions, done compressing, simplification of information relating to the case history, followed certain norms at SCC for giving case names, omitted the words like section, sec, rule, etc., and given only the number of the section, rule at the beginning of the quoted extract, made margin heading and the first clause, subsection or initial matter of section, rule etc., to run on instead of being let to start from a fresh line, done compressing of unquoted references and use of for parts, replaced the series of dots in the raw text with ellipsis, removed abbreviations such as sec, r, cl, and substituted them with full word, i.e. section, rule, clause, added hyphenation after the section, rule numbers which have alphabet suffixed to them, applied indentation of quoted extracts, removed full stops or word no, and given full forms of abbreviations to enhance readability and clarity. In addition to the above, capitalization and italicization is also made wherever necessary in the raw text, and punctuation, articles, spellings and compound words are also checked and corrected, if required, in the original text. The aforesaid inputs put by the appellants in the judgments would have had a copyright had we accepted the principle that anyone who by his or her own skill and labor creates an original work of whatever character, shall enjoy an exclusive right to copy that work, and no one else would be permitted to reap the crop what the copyright owner had sown. No doubt the appellants have collected the material and improved the readability of the judgment by putting inputs in the original text of the judgment by considerable labor and arranged it in their own style. But that does not give the flavor of minimum requirement of creativity. The exercise of the skill and judgment required to produce the work is trivial and is on account of the labor and the capital invested and could be characterized as purely a work which has been brought about by putting some amount of labor by the appellants. Although for establishing a copyright, the creativity standard applies is not that something must be novel or non-obvious, but some amount of creativity in the work to claim a copyright is required. It does require a minimal degree of creativity. Arrangement of the facts or data or the case law is already included in the judgment of the court. Therefore, creativity of SCC would only be addition of certain facts or material already published, case law published in another law report, and its own arrangement and presentation of the judgment of the court in its own style to make it more user-friendly. The selection and arrangement can be viewed as typical and at best result of the labor, skill and investment of capital lacking even minimal creativity. It does not as a whole display sufficient originality so as to amount to an original work of the author. To support copyright, there must be some substantive variation and not merely a trivial variation, not the variation of the type where limited ways, unique of expression available and an author selects one of them which can be said to be a garden variety. Novelty or invention or innovative idea is not the requirement for protection of copyright, but it does require minimal degree of creativity. In our view, the aforesaid inputs put by the appellants in the copy-edited judgments do not touch the standard of creativity required for the copyright code. However, the inputs put in the original text by the appellants in segregating the existing paragraphs in the original text by breaking them into separate paragraphs, adding internal paragraph numbering within a judgment after providing uniform paragraph numbering to the multiple judgments, and indicating in the judgment the judges who have dissented or concurred by introducing the phrases like concurring, partly dissenting, supplementing, majority expressing no opinion, etc., have to be viewed in a different light. The task of paragraph numbering and internal referencing requires skill and judgment in great measure. The editor who inserts para numbering must know how legal argumentation and legal discourse is conducted, and how a judgment of a court of law must read. Often legal arguments or conclusions are either clubbed into one paragraph in the original judgment or parts of the same argument are given in separate paragraphs. It requires judgment and the capacity for discernment for determining whether to carve out a separate paragraph from an existing paragraph in the original judgment or to club together separate paragraphs in the original judgment of the court. Setting of paragraphs by the appellants of their own in the judgment entailed the exercise of the brain work, reading and understanding of subject of disputes, different issues involved, statutory provisions applicable and interpretation of the same, and then dividing them in different paragraphs so that chain of thoughts and process of statement of facts and the application of law relevant to the topic discussed is not disturbed. Would require full understanding of the entire subject of the judgment. Making paragraphs in a judgment could not be called a mechanical process. It requires careful consideration, discernment and choice, and thus it can be called as a work of an author. Creation of paragraphs would obviously require extensive reading, careful study of subject and the exercise of judgment to make paragraph which has dealt with particular aspect of the case, and separating intermixing of a different subject. Creation of paragraphs by separating them from the passage would require knowledge, sound judgment and legal skill. In our opinion, this exercise and creation thereof has a flavor of minimum amount of creativity. The said principle would also apply when the editor has put an input whereby different judges' opinion has been shown to have been dissenting or partly dissenting or concurring, etc. It also requires reading of the whole judgment and understanding the questions involved, and thereafter finding out whether they judges have disagreed or have the dissenting opinion, or they are partially disagreeing and partially agreeing to the view on a particular law point or even on facts. In these inputs put in by the appellants in the judgments reported in SCC, the appellants have a copyright and nobody is permitted to utilize the same. The above case has thrown much light on the philosophy that should influence decisions on the question of originality in copyright. It also summarizes a large number of Indian and foreign cases on the issue. It also brings out the difficulties in applying the philosophy in particular cases and also the need to take care of the public interest. The standard of originality required in copyright is very low. At the same time, it is very difficult to lay down any specific standard. There has to be some original skill or effort, but not mere mechanical one. When a person makes a selection of works for a compilation, he exercises a judgment which can make him entitled for copyright for that selection. It must be the product of labor, skill and capital of one person. It must originate from the author and not copied from elsewhere. 1.5 Summary. In this unit we have looked into the various theories for protecting copyright. The origin and development of copyright law in UK and in India, the nature of copyright, the works protected by copyright and the principle of originality. We have seen that copyright is there to protect the moral and material interests of the creator and also is an incentive for further creativity which will add to the culture of the society. We have also seen that in UK, the copyright law emerged as a response to the challenges posed by the emergence of printing technology, and that Indian law closely followed the UK law till in 1957, we enacted an Independent Copyright Act, which is still in existence. We have seen that copyright is a bundle of exclusive rights which are of the nature of negative rights. We have also seen that copyright is bound by time and territory. We have seen that copyright extends to all original literary, dramatic, musical and artistic works, and also to cinematograph films and sound recordings. The concept of originality, we have seen, is fundamental to copyright. It is, however, a very low level of originality that is required for making a work eligible for copyright protection. Thank you for watching. We will see you in the next video with the next chapter.